So indeed, now for something completely different. Detectives are admired for their ability to solve mysteries using inferences from circumstantial evidence. However, the creators of detective stories usually do not rely solely on such evidence. A detective story would usually end with a climatic scene in which direct evidence is brought, such as the confession of the culprit, implying that circumstantial evidence alone is not enough. And there are grounds to believe that something similar to that happens in the courtroom. So I'll use the terms direct evidence and circumstantial evidence in a way that would be unacceptable to you, but I'll still do it. In the conventional meaning of the words, in this room, there's no such thing as direct evidence. Everything is inferential to some degree. But under the conventional understanding, direct evidence proves a material fact without the mediation of a deductive process, whereas circumstantial evidence requires an additional mental step of inference in order to determine whether the material fact did or did not exist. Some legal systems used to instruct fact finders to avoid basing liability exclusively on circumstantial evidence or to use special cautions when doing so. However, the prevalent rule in modern systems and the common wisdom among scholars are that in principle circumstantial evidence is and should be as admissible and as reliable as direct evidence. There are nevertheless some indications that people tend to be prejudiced against circumstantial evidence, and the host of justifications / explanations, mostly explanations, no justifications, were offered for that. The first one is inconclusiveness. So arguably, different inferences could be drawn from the same circumstantial evidence, and hence basing liability on circumstantial evidence is less safe than on direct evidence. Moreover, even if circumstantial evidence is objectively as reliable as direct evidence, the subjective probability assessment of the fact finder may still be that the subjective probability he or she attaches to the circumstantial evidence is lower. Then there's the issue of narrative. Eyewitness testimonies are verbal, vivid, and concrete. Circumstantial evidence often resembles deductive reasoning. It is pallid, general, unexciting. Hence, it is easier to form a coherent story of the events from direct evidence. One issue that was mentioned specifically in the case of statistical evidence is case specificity. The probability that a certain fact is true may be high. There's 80% chance that it was a blue bus, while the weight or resiliency of the evidence supporting the claim is low. Conclusions should not be based on probability estimates that rest on too little information or on general non-case specific evidence. Then there's the issue of responsibility taking. With testimonies, the witness is to blame for an erroneous verdict, whereas when it goes to inference, it is the fact finders who draws the inference. And so if you would like to avoid feelings of regrets if it would turn out that you decided incorrectly, you would refrain from making decisions on the basis of inferences. In his seminal 1992 article on naked statistical evidence, Gary Wells argued that, and I quote, "In order for evidence to have a significant impact on people's verdict preferences, one's hypothetical belief about the ultimate fact must affect one's belief about the evidence. And no such effect exists in the case of naked statistical evidence, as the statistics remains true even if the defendant is actually not liable." So this, argued Wells, is the reason why people tend not to rely on naked statistical evidence. Finally, willingness to ground liability on any evidence depends on how easily one can imagine an alternative scenario that would be compatible with the evidence. Since circumstantial evidence does not prove the material fact itself, it is easier to imagine such a scenario when the only evidence is circumstantial. All of these explanations can be challenged and have been challenged, and to examine them, my colleagues and I ran some experiments, some of which I'll describe today. So I'll describe 5 out of 11 experiments that are reported in 2 articles that are linked in the abstract to this presentation. One paper was published in 2014 and one is forthcoming. So the first experiment pertained to criminal liability. Law students, Israeli law students, were presented with, it was a between subject design, they were presented with one of 2 scenarios. So in the direct evidence condition, it said speed cameras were installed on a toll road. The probability of an error in the camera system is 2%. The speed limit on this road is 100 kilometers per hour. According to the camera, a driver drove his car at a speed of 125 kilometers per hour late at night. The other condition reads as follows, in Hebrew of course: cameras that document the exact time at which each vehicle passes by them were installed on a toll road. The cameras do not document the speed of the passing vehicle, but from the distance between the cameras and the time that elapses between the points they document, it is possible to infer the driver's speed in that section of the road. The probability of an error in the camera system is 2%. The speed limit on this road is 100 kilometers per hour. And according to the time elapsed and the distance between the two cameras, a driver drove his car at a speed of 125 kilometers per hour.
What's the probability of an error? Is the
This is the information that they received, and they couldn't ask for clarifications. But it's the same sentence in both conventions, in both conditions.
the previous one?
How do I go back?
This one.
They use computer.
This is the one that works.
It's the arrows.
The arrow keys.
The arrows. Doesn't work for me. Sorry.
The idea is that we don't know whether they may fail to identify the number plate of the car, or maybe it's something
You don't
else.
know anything that is not in.
These arrow keys.
Okay, so how you do? You go up.
Or back. Something else.
This one is not working, but this is working. Backwards, forwards.
Backwards. No, that's forward, and that's for. Oh,
That's forwards.
yeah, but it doesn't go any. One, two.
Forwards. Okay, these go backwards. I don't know why.
Neither do I.
No backward influence is allowed.
Okay.
So to go backward, you need to go forward, and to go forward, you need to go backward.
How do I get to up here?
Well, the prior one is
I hope you deduct this for my time.
Yeah. Only for the last one. I had it.
Now it doesn't work at all. It's you to blame. No, but both your responsibility and your blame. Okay. Okay. So now it's the enter that works. Okay. So it says the probability of an error in the camera system is 2%. You may interpret it as you wish. This is what the participants received. It's the same sentence in both conditions, and here are the results. The rate of conviction in the direct evidence condition was 81%. The rate of conviction in the inference condition was 60%. It was statistically significant, as you may imagine. I forgot to mention that in both cases, before answering the question, the participants were reminded that this is a criminal case, meaning that the burden of proof is beyond a reasonable doubt, and they were asked to indicate whether they would convict the driver.
Just on one point about the language used, the statement was the probability of error is 2%.
In the camera system.
Well, in both of them.
Yes, yes.
In both cases. I wonder if that was perhaps a misprint for the probable error is 2%. Because
I'm not a statistician. I can tell you what it said in Hebrew.
Sure.
and it was the probability, I think.
The probability that it makes an error is 2%. That error could be catastrophic.
Yes, but I don't know if this.
But if you
It's completely different, and we can't tell
I'm wondering.
These were law students.
we don't know what percent is different.
We just don't know what the sentence means.
We don't know what the sentence means anyway.
I don't assume that there's any reason to believe that one group. This was a random allocation of law students among the two conditions, and these were their results. I have reason to believe that judges are more akin to law students than to your gang. But let's leave it at that. So the other experiment was designed to examine the generality of the previous finding. It referred to eyewitness rather than technological evidence, and it also tested whether the results are mediated by the respondent's subjective probability estimate, and also to test the responsibility-taking hypothesis. Instead of asking participants how would you decide the case, we asked them how a judge should decide the case. So once again, it was a between-subject design. A tourist bus was stuck. A policeman who arrived on the scene, stuck in the middle of nowhere, on the way to Eilat. A policeman who arrived on the scene assisted the driver in arranging for minibuses to bring the tourists to their destination. In the direct evidence condition, the policeman got on the bus and saw that there were 54 tourists on it, while the bus permit allowed it to carry only 50 passengers. In the inference conditions, two minibuses arrived empty, were filled up, and drove away. It then turned out that 4 tourists were left, and an additional vehicle was summoned for them. Since each minibus had seats for 25 passengers, the policeman inferred that the bus driver had violated the terms of the permit. The driver was accused of carrying too many passengers. The judge thought that the likelihood that the policeman had miscounted the passengers was very low, 1 in 20. Now, the rate of conviction, there was a difference, and quite a large one. So about 65% of respondents thought that the judge should convict the driver in the direct evidence, and only 38% in the inference condition. As for the estimated probability, the difference was much smaller. So whereas in the direct evidence condition, subject said that there's 82%, on average, 82% that the driver actually carried an excessive number of passengers. It was 78% in the inference condition. The difference is not statistically significant, and it doesn't mediate the difference in the rate of conviction. The next experiment, antibiotics, broadened our focus to include civil litigation. Also, the question in this scenario wasn't whether a wrong had been committed, but rather who committed the wrong. And finally, since some jurisdictions set particularly strict limits on drawing an inference upon an inference, in the United States at least, the precedent experiment compared not only direct evidence and inference, but also single and double inference. So respondents were asked to imagine themselves as a judge in a suit for damages filed by a small dairy against a farmer. The farmer sells the dairy the milk he produces. The farmer should make sure that there are no antibiotics residues in the milk. The milk is delivered to the dairy by a tank truck that transports the milk of 2 farmers. Since the milk is mixed in the trunk, a sample is taken from each farmer's milk before pumping it into the tanker, and the samples are delivered to a laboratory where they will be examined if need be. The dairy sues for damages, claiming that the farmer provided milk containing antibiotics residues, and as a result, the dairy suffered considerable loss. In the direct evidence condition, when the production process failed, the milk samples of the two farmers were examined. This examination revealed that there were antibiotics residues in the defendant's milk and no residues in the other farmer's milk. The results are 85% reliable. It is undisputed that the source of the antibiotics residues could only be milk from one of the farmers. In the single inference condition, when production process failed, the milk samples from the two farmers were about to be examined. But it turned out that the sample of the defendant's milk had been lost in the laboratory. Hence, only the other farmer's sample was examined, and this examination showed no antibiotics residues in the other farmer's milk. The overall results are 85% reliable. Then in the double inference condition, there was a third possible cause for the failure of the production process. It was first eliminated, from which it was inferred that it must be antibiotics, and then one sample lost. They examined the other one. Once again, it said that the results are 85% reliable. Since there was no significant difference between the single and double inference conditions, we collapsed them together in the analysis. The rate of accepting the claim was different in the two conditions, and quite significantly so. So in the direct evidence condition, almost 82% ruled in favor of the dairy, whereas in the inference condition, only 40%. As for the estimated probability, there was a difference. It was about 82% in the direct evidence condition, only 65% in the inference condition, and of course there was a correlation between people's subjective probability and their decision, but the difference between the conditions with respect to accepting the claim was not mediated, once again, by the difference in probability estimates. I'll now describe, so in a set of three experiments, out of which I'll describe one, we sought to examine whether there is an anti-inference bias only when judicial fact finders are imposing liability, or also when they confer benefits. So according to prospect theory, the theory, Tversky and Kahneman's theory, for which Daniel Kahneman won the Nobel Prize in economics, people love to gain, people hate to lose, but they hate to lose much more than they love to gain. So if I would offer you to participate in a gamble where you can, with equal probabilities, or I'm now afraid to use those words, with equal probability you may either gain 100 pounds or lose 100 pounds, most of you would not wish to participate in the gamble. If I would offer, about half of the people would take the bet if it is either losing 100 or winning 225. So the ratio is more than twice as large. The gain should be more than twice as large for the disutility of losing to be equal the utility of gains. And this preference or this perception has a close parallel in common sense morality. So in common sense morality, in deontological morality, the prohibition on harming other people is stronger than the imperative to benefit other people. So both of these things led us to the hypothesis that the anti-inference bias would be stronger in the realm of losses than in the realm of gains. And so to examine this hypothesis, we ran an experiment in which we used a modified version of the antibiotics vignettes. So once again, there were two farmers, one tanker. They produced equal quantity of milk. the milk is mixed in the tank, 2 samples are taken, and subjects were asked to decide a dispute between the farmer and the dairy farm. In this version of the experiment, it was not given which party is the plaintiff or the defendant. There's a dispute and you have to decide them. In other versions there was a plaintiff and a defendant. We employed a 2x2 factorial design. There were in 2 of the conditions involved gains and 2 losses. 2 of the conditions circumstantial evidence and 2 direct evidence, and we crossed those 2. So the vignette described a contractual dispute. In the 2 gain conditions, the contract between the farmer and the dairy stipulated that every day in which the milk's protein content exceeds 5%, the farmer is entitled to an additional sum of $1,000. In the 2 loss conditions, every day in which the milk's protein content is below 5%, it stipulated that a sum of $1,000 is deducted from the payment, the regular payment to the farmer. In the gain conditions, the vignettes then indicated that one day the milk in the tanker contained 6% protein. In the direct evidence condition, both samples were examined. There were 7% protein in the litigant, the farmer that is part of the litigation, and 5 in the other one. In the loss and the inference, once again, we lost. One of the samples was lost, and only the other one was examined, and it had only 5%. As I told you, they produce equal amount of milk. In the loss conditions, the milk in the tanker contained 4%. In the direct evidence, both samples were tested, 3% in the sample of the farmer in question, 5% in the other farmer's sample, and once again, in the inference condition, only the other farmer's milk was examined. And in all conditions, the reliability of the overall results was identical, and it was 80%. So we asked the participants a series of questions. The first question was a decision question. How would you decide the dispute? Please specify a number between 1 and 9, where 1 indicates a sum of 1,000 should certainly be added to or deducted from, depending on the gain or loss conditions, from the farmer's payment, and 9 indicates that it certainly not be, and there's a scale between 1 and 9. There was a probability question, assessment of the probability, like in previous experiments. And finally, while the previous experiments indicated that subjective probability assessments do not explain the anti-inference bias, we wanted to examine another hypothesis, namely that it is people's confidence about their probability assessments that explains the bias. Perhaps people are reluctant to rely on circumstantial evidence, not because it produces lower probability estimates, but because people's confidence in those assessments is lower. So this is akin to the Ellsberg paradox, or the ambiguity aversion. Perhaps you don't want to make decisions when the data is more ambiguous. We thus added the confidence condition, asking how confident are you about the probability assessment that you made. The results are presented, the results of the decision question are presented in the diagram, and we inverted the 9 here is greater, means greater willingness to rely on the evidence, whatever the evidence might be, for the sake of presentation. And so if you look on that side, this is the loss conditions. The difference in the willingness to impose liability is quite large, highly statistically significant in the domain of losses, whereas the difference in the realm of gains is much smaller, and is not, it is marginally statistically significant. The interaction between the domain and the type of evidence was statistically significant. Once again, both the subjective probability and the confidence were correlated with the decision, but once again, none of them mediated the results. these results, the same results, were replicated in two other versions of the same experiment, including one within subject. So we presented each subject with all four conditions in random order and asked them to decide all four questions, all four conditions. So gain direct, gain indirect, etc. And we got the same results. And also in that within subject version, we made sure that in all conditions one sample was lost. So it was either this farmer's sample or the other farmer's sample that was lost, and so in each case only one sample was examined, and those exact, or not exact, but the same picture emerged. In the last experiment that I'll report today, we examined whether it would be possible to eliminate the anti-inference bias by drawing subject attention to the facts that were proven and or to the logical inevitability of the inference. To that end, we used once again the antibiotics vignette and added to the original decision probability and confidence questions two new questions. One, which I would call logic, was as follows: given that the source of the antibiotics residues could only be the milk of one of the two farmers, would a proof that there were no antibiotics residues in the other farmer's milk necessarily imply that there were antibiotics residues in the defendant's milk? That was the logic question. Then there was the proof question, taking responses by the hand. Was it proven that there were no antibiotic residues in the other farmer's milk? So we used 5 different conditions, 1 direct evidence, 4 other inference conditions. In the direct evidence, the logic and proof questions were added at the end of the other 3, the original questions, and since subject could not go back and change their answers, those questions could not have affected responders' answers. The same was done in the first of the inference conditions, in the no guidance. So once again, the 2 questions were at the end, they couldn't affect answers. In the proof before condition, only the proof question was put in at the first, the logic at the end, logic before the other way around, and logic and proof before, both questions were asked before the decision question and other original questions. And here are the results. So on the left, you see the direct evidence willingness to rely on the evidence. The other 4 are the no guidance, the logic before, proof before, and logic and proof before. As you may see, there is a considerable difference and statistically significant difference between the direct evidence and all other 4 conditions. There is no statistically significant difference between the 4 inference conditions. There is a statistically significant difference between the direct and any of the other 4, and there is not even a statistically significant difference between no guidance and the other 3. Or it's a margin. The last one is marginally significant. The difference between no guidance to the other 3 is okay. So let's summarize our findings. All experiments demonstrated an anti-inference bias. Respondents were far more reluctant to impose liability based solely on circumstantial evidence than on direct evidence. The anti-inference bias was manifest across different scenarios, was true for both criminal and civil liability, was common to both Israeli law students and American law persons, was evident both when the disputed question was whether a wrong had been committed and when the question was who had committed the wrong. The anti-inference bias was not affected by the severity of the expected sanction. These are 3 experiments that I did not report today. Some of you might find it counterintuitive, but when the sanction was harsher, there was no greater anti-inference bias. The bias was not mediated by subjective probability assessments or by confidence in probability assessments. It was common to technological, scientific, and eyewitness evidence, And it was manifest when the circumstantial evidence was case-specific rather than merely statistical, thus rendering most of the explanations that I started with irrelevant. The bias was exhibited both when respondents made a decision and when specified how another person should decide, so it's not, at least not all about responsibility taking. It was found in both between and within subject experimental designs, meaning that it is not wholly unconscious. People stick to that distinction even when they are aware of it. And it was considerably less pronounced in the domain of gains than in the domain of losses, which plausibly means that there's also a normative judgment involved and not only an epistemological one. And as you saw, it was not amenable to simple debiasing techniques. So much like other heuristics, the anti-inference heuristics assist people to make judgments under uncertainty. Ordinarily, when we see something with our own eyes, or when someone tells us that she saw something herself, that event actually happened. This is not necessarily true of conclusions drawn from circumstantial evidence. However, when we overgeneralize this experience, this heuristics gives rise to systematic error, and in as much as it reflects also judgments about when it is appropriate or when it is fair to impose liability based on different types of evidence, so that makes things even more complex. A few words about normative implications. So assuming that the law strives to enhance truth finding, which I think most of you believe, legal systems might improve the quality of fact finders by debiasing this bias or overcoming it, however, this conclusion might be too hasty. First, it is not clear that debiasing is necessary. Perhaps all we found is true of law students and laypersons, and professional judgments. Professional judges are not liable for these heuristics. I can tell you, based on dozens of other studies, they all show that judges are human beings. There are sometimes differences, but basically they are human beings. I even have another study where I show that lawyers are human beings, but
Prove that.
it is not clear that trying to overcome or debiasing the biases is at all feasible. In our experiments, we didn't do very well, and what we know from studies of jury instructions is that more often than not, jury instructions do not debias people's heuristics and biases. And what is less obvious, it is not even clear that it is desirable, because it might be that for either instrumental or intrinsic reasons, we want judicial decision-making to cohere with the prevalent normative and epistemological intuitions of the general public. And if this is so, then we perhaps wouldn't like to create a discrepancy between what the public believes is the right way to make decisions and how the courts do it. But there are other means, indirect means, besides direct debiasing, that might be and actually are used. So one way is legal presumptions. Legal presumptions are used by legislatures, and what they mean is that the fact finders does not have to draw any conclusions. So the fact finders has to determine the basic facts. The law then presumes so if I have to decide whether the accused had a certain amount of drug in possession, then there is a legal presumption that if the amount is big enough, he must be a drug dealer. But the fact finder doesn't have to draw this distinction. It is on the accused to disprove this presumption. It may be possible to change the substantive rules. We may criminalize things in order to avoid the need for inference. For example, all kinds of preparatory offenses. So we might say that it is an offense to carry guns next to a bank, or things like that. So you don't have to deduct anything from the fact, from that fact. This fact alone is a crime, and the law does such things. And finally, we can change the initial behavior. So the take-home lesson is use speed cameras not two-camera systems. Thank you very much.
Phil?
I'm a little confused about the milk and the antibiotic scenario. So in your direct condition, a single measurement is made on one farmer's milk. And in the inference condition, there are two measurements, one made on the overall milk and the other made on the other farmer's milk. But you've told them that each measurement has uncertainty about it.
No, I didn't say that each measurement. I said the results of the overall measurements. You can look at the exact wording in the article. But anyhow, I have a better answer, and the better answer is that in the version of the protein, we used there was a lost sample in both conditions. So in both conditions, it was only one sample that was lost, and there was an anti-inference bias.
But in your indirect condition, the conclusion depends on two separate measurements, whereas in the direct condition, it depends only on one.
Yes, but we
So
said
if the measurements are uncertain, aren't you more likely to be wrong if you have to rely on two uncertain measurements than just one?
we tried to formulate it so that the overall reliability of the overall reliability of the two tests or the three tests, depending on how many inferences there were 80 or 85% reliable. But anyhow, even if you don't buy that, we had another experiment in which, in both conditions, one sample was lost. So in one condition, they examined only the farmers in question sample. In the other conditions, only the other farmers sample, and still, so there was a single experiment. There was a single measurement in each one of them. It was the same reliability. We even asked them, given that if it's not that, it must be that. Is it so? If it's not that, is it that? And they answered that question, but it didn't change their. It didn't eliminate their anti-inference bias.
Christian?
But continuing what Bill says here, I mean, you said that you formulate it in such a way, but actually when the formulations are ambiguous.
Yes.
Yes, they
So
are.
it is possible. For example, with the camera.
So let's move directly to my second answer.
Continue. Yeah. With the cameras, the formulation was that there is an error of something that there is something wrong with the camera system. So if you have two cameras, one interpretation is, okay, there's a 2% chance that there's something wrong with this camera, and in addition, there's a 2% chance that there's something wrong with the other camera. Or, because it's ambiguous, it can be interpreted that it's 2% chance that there is something wrong with both cameras, or the whole, seeing the cameras as a system. And then, of course, there is also the thing that you are showing that a third source of error in this case is the distance between the cameras. So people might think, well, maybe someone measured the distance wrong between the cameras. So if one option introduces several sources of error, and your way of phrasing the risk of error is so ambiguous, so it's possible to interpret it as, well, there is actually a greater risk for error in this case, then it's perfectly rational for people to answer differently to the two questions.
I agree.
You don't have to go into Kahneman or anything.
I agree, but if that were true, then so if we presented only one experiment, you were very convincing. However, we saw that if you were right, this should have affected first and foremost the probability assessment. and in the camera system, there was practically no difference in the subjective probability assessment. Second, the bus scenario had its pitfalls. I agree. So this is why we try to repeat it with other scenarios. None of them is perfect. So you may try to come up with some kind of explanation that does not rely on a heuristic. I believe that by the end of the story, taking the 11 experiments with all their variations together, we are onto something. That's all I can say. And it's not different than the other experiments, the experiments in the Wells effect, etc. This is how you examine those things.
There were Ulrike
Yeah,
and Jane.
I just want to have one more crack at that. I think, to me, the problem sort of started in your early description where you said you talked about these circumstantial inferences as being deductive, but none of the circumstantial evidence inferences that you actually present in any of your scenarios are deductive inferences. So there's no reason whatsoever to treat them as probability preserving in the first place, right? So the problem isn't just about the formulation of one particular, okay, this is misleading or this is ambiguous or whatever. Fundamentally, the inference you're dealing with in these scenarios is an ampliative one. So there is no reason when you change the evidential basis, right, to think that these numbers should match in any way whatsoever. So why you would call this a bias, this difference, is kind of really not clear to me in the first place. Like, where does the constraint come from that these these numbers are supposed to be the same? Like, from what normative framework of inference do you derive that?
Well,
So I'm afraid that...
from pure probability, they should be the same. That's how you kind of try to construct it, right? From pure probability, they should be the same.
No?
I mean,
Could we hear the speaker's answer, please?
Actually you can't, because the speaker would have to take a lesson after his presentation to understand the question. So, which I'm not cynical. I would be happy if you could explain to me in greater details, because I'm using common sense notions. So I might be missing something important, and I would be happy to learn more about it.
let's just hear yours.
So I certainly find it quite interesting to see what you've done. And listening to the discussion reminds me of when I ventured a little bit into this field, of the importance of actually, if you want to do anything, trying to get as many people from as many different backgrounds to at least agree on the questions you're trying to ask and the answers. Obviously you can't get everybody, but it does help if you get the adversaries in before you do the experiment rather than afterwards. One of my concerns is much more how much is known about generalizing from these results, because the work I've seen of Tversky I regard as, well, I suppose the expression I would use is laughable, because he seems to draw conclusions from 8 Israeli high school children that he generalizes to the entire world. And I have some reservations about regarding either law students or people who make a living by answering online questionnaires as the most relevant populations.
Yeah, so of course there are drawbacks to experiments, but as you're well aware, there are drawbacks to observational studies. At least we can try to look for causation here. In other experiments, we recruited litigating lawyers to answer those questions. Judges are not very cooperative in Israel in those regards. You know, even paranoids have enemies.
You've used Enter for
Yes, the last experiments that I mentioned were done on Turk, and I think it has some ideological component in it, because prospect theory and many others, the basic insights of judgment decision making were replicated in hundreds of studies.
Hundreds, the ones that I've looked at, hundreds of very low quality studies, none of which would be accepted in the medical world as worth paying any attention to, because they'd be assumed or be demonstrably seriously biased. That's my concern.
So
Standards are just very different.
Yes, so that's basically a complaint against the organizers for inviting a person who does.
As I said, I think your talk is very interesting and very important. But in order to have influence, All I'm saying is I think they're important ideas, but I think in order to have influence, there are more questions and more collaboration needed.
Which I always welcome.
We have a reception now, so this Professor Zamir